Hello everyone, welcome back to Ask Prashanthi. I'm your host, Prashanthi Reddy. I'm an immigration attorney and I'm dedicated to helping you navigate the sometimes challenging and often rewarding world of US immigration law. In this show, we will tackle your questions, those questions that are real pressing concerns that you have about visas, a green card, citizenship, and everything in between. We pull questions from our channel right here on YouTube as well as on LinkedIn, Facebook, Instagram, and of course, all those excellent submissions from our website. Okay, let's start with the first question. This question is from Raju, and this question was posted on my YouTube channel. And the question is, can I coordinate a project without getting a salary, paycheck, if I'm on a H-4 and I don't have an EAD? To answer that question, no, you cannot coordinate or work on a project or participate in any other gainful employment if you do not have work authorization. Since you're on a H-4 and you do not have an EAD, you unfortunately cannot coordinate or work on any project. And if you do so, you'll be violating your status. The next question is from Hung Tao Leo. And this question is also from my website. And the question is, I have an active H-1B visa. My employer is planning to terminate me. They will put me on a 2-month unpaid leave and then formally terminate me at the end of this leave period. When will my grace period begin? From the day I was placed on unpaid leave or from the date of the formal termination? The answer to this question is that they calculate the 60 days grace period from the date of your termination, so from the last day of employment. If you have unpaid leave, if you have leave remaining, or you have your employer is willing to put you on unpaid leave for whatever reason, that could be a separate DOL issue as to why he's not paying you when you're actually working for them. But from the USCIS point of view, it's from the date of termination, and so I would want you to make sure that you have a clear date of termination and get proof of that. That could be a letter from your employer formally terminating you and advising you on what your last date of employment is. The next question comes from Munna Kumar Shah, and this is also from my website. And the question is, hello, my employer is filing for a H-1B cap exempt case. I got the offer letter from them, and as soon as I got the offer letter, I stopped working in my home country. So my employer is filing my petition with USCIS now, and since currently I'm not working, will this affect my petition with USCIS? Will currently not working affect my H-1B visa filing? Munna Kumar Shah, to answer this question, no, it does not. Your H-1B does not depend on whether you are employed or not employed in your home country right now. Your H-1B petition depends on whether you qualify based on your educational credentials, and it's possible that they might need work experience also if you're not qualified based on your education. But it doesn't have anything to do with whether you're employed or not employed in your home country at this point of time. The next question is a question from my audience. This is frequently asked. What family members are eligible for a green card? To answer that, immediate relatives of US citizens are eligible for a green card. So spouses of US citizens, unmarried children under 21 are eligible. Parents of US citizens are eligible, as well as children under 21, as I said already. And children can sponsor, US citizen children can sponsor parents as well if they are over the age of 21. There are other family members as well of US citizens. They're called preference categories. They're not immediate relatives, so there is a visa number availability issue for these cases. Unmarried sons and daughters over 21, um, unmarried adult children of US citizens, that's who they are. Married sons and daughters, so regardless of age, married sons and daughters of US citizens can also be sponsored, but it comes in a different category. Siblings of US citizens at least 21 years old can also be sponsored under the brother and sister category. This is the F4 category. Again, this is highly backlogged, so you should look at the priority dates on the visa bulletin. In addition to that, family members of green card holders can also be sponsored. So spouses and children under 21, unmarried children, can be sponsored by permanent residents. The next question is also a frequently asked question from my clients. How much does it cost to sponsor a green card for a family member? The answer to that is that the estimated cost varies. It depends on where you are, whether it's a consular processing, that is, if you're outside the country, or if you're in the country filing adjustment of status, and if you're filing for your I-765, which is employment authorization and advance parole, or you choose not to file for them, or you're filing for one and not the other. But in general, the cost could range from $2,265 to $3,605 for applicants living in the US. For applicants living abroad, it can cost from around $1,300 plus the medical examination fee. And this is true even for people living in the US, there is a medical exam fee. But please note, these fees are only cover the government filing fees. There may be additional costs, like I said, the medical exam fees, translation fees, if you have any documents that are not in English, and also the attorney fees. And USCIS fees also are subject to change, so make sure that you go to the USCIS website to ensure that you know what the correct fee is at the time of filing the application. Hello all, hope you liked the earlier episode of Ask Prashanthi. If we missed your question last week, don't worry, we will cover it in the next week's episode. We're ready for your new set of questions, so just follow the link in the video description and drop your question there. See you next week.